Hello everyone, and welcome to the August 2024 episode of my PIP Monthly. As always, I'm your host, Amber Rouse Holloway, and I'm an executive partner here at our Troy office. Our August 2024 topics include a case law discussion. This is somewhat of an older case, meaning 2022, but it's an unpublished opinion, Yee versus AAA. And then we will move on to trending topics in PIP litigation. And here I wanted to discuss negotiating terms of arbitration. And to go along with that, the case of Alice Jenkins versus Suburban Mobility Authority for Regional Transportation, which was issued in 2022 as well. Now, the case of Yee versus AAA is an unpublished opinion from our Court of Appeals, which was issued February 24th, 2024. Now, here, ultimately, the Court of Appeals reversed the trial court's decision and held that pursuant to the provision found in plaintiff's insurance policy, there was no coverage because plaintiff's husband owned the subject vehicle and resided with her. The court ultimately remanded this case to the trial court for entry of judgment as to plaintiff's UIM claim in favor of defendant. By way of background, married individuals who are seeking underinsured motorist coverage of a policy of insurance purchased by the couple must look to the language of their policy to determine if coverage exists. Now here, the court took up the question of whether plaintiff is excluded from seeking UIM coverage under the AAA policy issued to plaintiff and her husband that provided UIM for her 2023 Honda CR-V and her husband's 2013 Ford Escape. Now, like I said, the Court of Appeals did reverse the trial court's decision and remanded the case back to the trial court for entry of judgment in favor of defendant. The court reasoned that the policy excludes UIM coverage for motor vehicles owned by a policyholder or residents of the policyholder's household. Here it was undisputed that plaintiff resided with her husband and that her husband owned the subject motor vehicle that he insured, the 2013 Ford Escape. Further background, the case arises out of a motor vehicle accident that occurred in July of 2018 when the plaintiff was injured as a passenger in that 2013 Ford Escape. Plaintiff filed a negligence claim against her husband, which resulted in a settlement of $20,000. The settlement was finalized pursuant to the AAA policy they shared, under which the maximum policy limits of $250,000 were reduced due to the relationship between the parties, i.e. marriage. Plaintiff then sought UIM benefits from defendant by claiming that her husband is underinsured because her damages exceeded the bodily policy limits of $20,000. Defendant informed plaintiff ultimately that the policy offers her no coverage for the UIM benefits, which led to plaintiff filing suit. Now here the court highlighted the Dawson v. Farm Bureau opinion, which a lot of us are familiar with, where the Court of Appeals held that courts must construe and apply the unambiguous contractual provisions as written in a policy of insurance when determining whether or UIM coverage is available, since such benefits are not mandatory by Michigan law and are thus contracts. Now, here, the trial court did deny defendant's motion for summary disposition and held that there was a question of material fact as to whether coverage exists in light of the two UIM provisions. The trial court entered a stipulated judgment in favor of plaintiff in the amount of $230,000 and stayed executing said judgment until defendant exhausted its appellate remedies. Now, the two provisions are outlined as: one, uninsured motor vehicle and underinsured motor vehicle does not include any motor vehicle which is owned by you or any resident of your household. And then the other one that we have to consider is underinsured motor vehicle means a motor vehicle whose ownership, maintenance, or use has resulted in bodily injury of an insured person, for which the sum of the limits of liability under all bodily injury liability insurance policies, bonds, or other security required to be maintained under Michigan law to the driver or legally responsible person is less than the limits of the underinsured motorist coverage provided the insured person at the time of the accident. Now here, the Court of Appeals first determined that there was no ambiguity in the clear and specific contractual provisions regarding what qualifies as an underinsured motor vehicle. The second provision of paragraph 4 clearly stated and clearly defined underinsured motor vehicle, while the second paragraph contains an exclusion to the definition. The purpose of these exclusions is to limit coverage in specific instances. Therefore, the provisions must be interpreted as written and applied to the facts here. Ultimately, the Court of Appeals found that plaintiff's argument that her husband's bodily injury limit impacts her insured status, rendering him underinsured, to be preserved for the purposes of appeal. The court also found that plaintiff's position to be irrelevant because it fails to address defendant's arguments that she is excluded from coverage because she is an underinsured, an assertion that has no bearing on plaintiff's husband as an alleged underinsured individual. Additionally, it's important to note that plaintiff's policy offers coverage for injuries caused from an accident concerning an underinsured motor vehicle rather than an underinsured motorist. The UIM section here outlines that defendant must pay for the UIM benefits when it arises out of the ownership, operation, maintenance, or use of an underinsured motor vehicle, not motorist. I.e. here, this vehicle was obviously insured. Plaintiff further contended that she was claiming benefits for coverage for her vehicle and not coverage for her husband's vehicle. Nevertheless, the Court of Appeals found this argument unconvincing because plaintiff already claimed the maximum benefits provided by her husband's policy, so her own coverage applies here. Ultimately, the exclusionary provision in the plaintiff's policy precluded her husband's Ford from qualifying as an underinsured motor vehicle, and thus she cannot claim underinsured motorist benefits. Now moving on to trending topics in PIP litigation, negotiating terms of arbitration. As we just discussed in the prior case law discussion, contracts control. Here in the form of an arbitration, the contract is everything, or the arbitration agreement as we like to call it. And so the terms, selection of the panel, the controlling law, what to do if the arbitrators can't agree, all of that must be included in the contract, and the contract must be as specific as possible because the arbitration agreement is the contract and it is the controlling device. Obviously, the court can be called upon to interpret the contract, but that is why it is even more important to ensure that the terms of the contract are clear at the forefront of arbitration. Now, like I said, selection of the panel. Now, this is a nuanced art form. Some cases you're better served with an all-neutral panel, meaning 3 neutral attorneys as panelists, versus the 3-panel party system when you get a neutral, a defense, and a plaintiff. Sometimes I've noticed that arbitrations with that 3-panel panelist selection, you have a difficult time finding who can or who will agree to being your neutral panelist. And that's just because of politics. You know, you get the defense panelist who typically favors the defendant, and you get the plaintiff panelist who typically favors the plaintiff. But then you get that neutral who's going to be the tiebreaker and piss one side off. So a lot of times you get some pushback from people that typically serve as neutrals when you're asking them to serve as a neutral in a 3-panel selection. But on the contrary, when you get 3 neutrals, and again, this is specific for different cases, but when you get a 3 neutral panelists, they don't have any bearing in the game. They can disagree with whomever they wish to disagree with and agree with whomever they wish to agree with. So for certain cases where a defendant or a plaintiff may have a strong relationship with their person, the panelist they're selecting, or you feel like they may have that relationship that will outweigh the defendant's relationship and outweigh the neutral's relationship, it may be best to seek a 3-panel or a 3 neutral panel where typically no panelist favors either side. Now, When determining the conduct of the hearing, it's important to outline what rules will be applied, or are we going to be relaxed on the rules of evidence? Are we going to be relaxed on objections and things of that nature? Now, typically, in most arbitration agreements, it's found that the strict construction of the Michigan rules of evidence are not adhered to. It's more like a formal, very formal facilitation, whereas one side makes their plea and the other side makes their plea. And then sometimes you have witnesses that would like to testify. But even when the witnesses testify, the rules of evidence are somewhat laxed because it's easier, simply easier. Now, it's also important to outline in the arbitration agreement or arbitration contract whether live witness testimony is going to be allowed. And live witness testimony meaning the plaintiff, meaning the defendant, meaning the doctors and experts or treating physicians. Some arbitrations, you don't want those coming in, and that may be why you're choosing to move forward with arbitration versus trial. If you have a defendant that won't present well in front of an arbitration panelist, let alone a jury, you may want to outline in that arbitration agreement. Or hindsight, if you have a plaintiff that may present really well, you may want to try to outline in your ARB agreement that there's going to be no live testimony. Now, and I've already talked about the admissibility of evidence. You got to decide in the arbitration agreement what type of evidence you're going to bring in. Are you guys going to allow all the medical records? Are you guys going to only allow things that were obtained during discovery? And this is where it's important to either be silent on those things. For example, if you have a surveillance report that you obtained or received after the close of discovery, you may want to be more relaxed on the admissibility of evidence being brought in after the close of discovery. Now, effects of the decision. Now, typically when you proceed to arbitration, the arbitration is the final award for whatever type of case it is, whether it's a PIP case or a non-economic BI case, but you want the arbitration to be the final determining factor. Obviously, we've opted out of trial at this point, but when you get a 3-neutral panel or a 3-panel defense, plaintiff, and neutral panel, it's important to determine what's going to happen if the arbitrators can't agree. And in that situation, you can put in the contract that it may be re-arbitrated with a new panel, or that they must come to some sort of agreement. But ultimately, you do want to put in the arbitration agreement that any disputes that are unable to be resolved by the parties be resolved by the court that the matter was previously filed in. And then limits on the awards. Now here we have what we like to call high-low agreements, and that's when, unbeknownst to the arbitrators, unbeknownst to the panel, there's either a high that controls or a low controls, and this is really a game of negotiating. If the plaintiff wants a super high, you want a super low, and you want to try to minimize the high as much as possible. Now, the case of Alice Jenkins v. Suburban Mobility Authority for Regional Transportation is an unpublished opinion. This case talked about issues subject to arbitration and essentially said that arbitration is a matter of contract. Decision was unanimous, although unpublished, and ultimately the Court of Appeals affirmed the trial court's order granting defendant Suburban Mobility Authority for Regional Transportation, or SMART buses, motion to strike and exclude certain areas of Plaintiff Jenkins' claim for no-fault benefits because she had assigned those to various medical providers from arbitration. The Court of Appeals held here that the trial court had jurisdiction jurisdiction to decide whether Jenkins' assigned claims were subject to the arbitration agreement, and second, that Jenkins' assigned claims were not arbitrable under the terms of the arbitration agreement because those claims were no longer hers to pursue. So again, it's important to outline those potential issues that you may see coming in that arbitration agreement. And that is all I have for you guys today. As always, thank you for attending My PIP Monthly. If you have any questions or concerns, please feel free to reach out.